Welcome to this online event. Due to the current circumstances, in support to the blockchain community, CBBC reached out to our ecosystem partners, MLL and PWC, to develop into a really relevant topic: financial support for Crypto Valley companies to face the COVID-19 crisis. Without further ado, I will pass the word to Dr. Rito Luttinger to develop into the first topic.
Thank you, Fabiola, for the kind introduction into this subject. My name is Reto. I'm a lawyer at Meyer-Lustenberg-Laschenal. I'm a senior associate there in the banking and finance team. I'm the co-head of our DLT and blockchain industry group and an expert in financial market regulations. You can also see on the slide my contact details if you want to contact me and reach out to me. Now, as we all know, the Federal Council implemented some special measures in order to make it a little bit easier for companies during this very terrible coronavirus crisis. And I like to present you at least especially two subjects today. First, bridge loans for small and medium enterprises, and second, payment deferrals for social contribution payments. Let us start with SME bridge loans. The Federal Council decided to grant very easily bridge loans for small and medium enterprises having liquidity issues up to a total amount of $20 billion. Even as we assume that he's discussing today or beginning of next week to even raise this amount to $30 billion. So this will be available for companies being founded before 1st March of 2020. And if they had annual revenues in 2019 below 500 million Swiss francs. The loan amount you are eligible to is determined by your annual revenues. So you can request a loan for maximum 10% of your annual revenues in 2019. For startups, however, there's a special method for to estimate the turnover. They can take their wage sum in the last year and triple it, and get a loan between 100,000 and 500,000 Swiss francs. Depending on the amount of the loan, the Federal Council implemented two types of loans. We have, on the one hand, for smaller amounts, the COVID-19 loan, and for bigger amounts, the COVID-19 loan plus. So how do they differentiate? The smaller loan goes up to 500,000 Swiss francs. It is fully secured by the Swiss federal government. There is zero interest to pay, and there's the duration of this loan is at maximum 5 years. In several cases, if there are very hard circumstances, maybe 2 years more. One of the most important features of this smaller loan is that it does not count for your indebtedness calculation according to the Swiss Code of Obligations. On the other side, we have this bigger loan. It goes up to 20 million Swiss francs. There, the Swiss Federation is securing only 85% of the loan. The other 15%, here on the right side of the slide, are secured by your bank where you apply for the loan. So this makes it a little bit special because we have different conditions for both parts of this loan. The part secured by the federal government has an interest rate of 0.5% and is actually also, the duration is also maximum 5 years. And important to know here is that this loan does count for your indebtedness calculation. So it's real debt you have to consider when you calculate your indebtedness. The other part, which is secured by the bank, this 15%, there the bank has the possibility to negotiate with you the specific interest rate. It has the possibility to ask you for additional securities there. And maybe also important to know, for this kind of loan, there's at least a small credit check done by the bank. Overall, important to know is that you have no right to such loan. So every bank can reject any request filing if they want. However, we have at the moment over 120 banks in Switzerland who participate in this program, and even the Federal Council allowed even to Post Finance, who is normally forbidden to grant loans, to at least grant the smaller one. So, however, before deciding to obtain such a loan, it is important to think about also some restrictions which you have to comply with during the period of the outstanding loan. And these are quite severe for some companies. Most importantly, during the outstanding loan, you are not allowed to pay out dividends nor royalties. You must not reimburse any capital contributions to your shareholders. You are not allowed to grant any loans to refinance personal or shareholder loans, to repay group loans, and last but not least, to transfer such liquidity from such COVID-19 loans to other affiliated companies outside of Switzerland. So overall, companies that are part of an international group or that work with a huge amount of debt or are in cash pool arrangements must really think through this kind of taking loan based on these restrictions. Finally, there are also some criminal penalties. There's a fine up to 100,000 Swiss francs, or even a more severe penalty if there is a more severe offense based on the Swiss Criminal Code, if you, on the one hand, willfully make false statements when obtaining such a loan, or on the other hand, if you willfully violate one of these restrictions presented on the slide before. If you decide to apply for such a loan, we have a look first at the smaller one, the COVID-19 loan. You go to the website covid19.easygov.swiss. You download there the respective loan agreement for a COVID-19 loan. You fill it out, sign it, and print it out, sign it obviously, and then send it to your bank, either as a scanned copy by email or by physical mail. The bank will simply do a check if this agreement is complete. No big credit check, no big other checks, simply if it's complete. If it's complete, the bank will pay out the loan within around 30 to 60 minutes if you are an existing customer of this bank. Then it will automatically be secured by a guarantee of the surety organization. On the other side, we have the bigger loan, the COVID-19 loan plus. It functions similar. You go to this website, you download the form. It's only a loan request and not a loan agreement, because if you send it to your bank, they will start with you negotiations about the interest rate and possible additional securities. Only once you have agreed on these terms, the bank will forward this request to the surety organization, and once they grant their surety, and that will not be the problem at the moment, the request and agreement is complete, and the bank will pay out to your bank account the loan amount. This normally takes, if you go to your house bank, it's intraday at the same day. Finally, to conclude my presentation, I want briefly present the second measure the Federal Council implemented. It's payment deferrals for Social Security contributions. There you have two options. Maybe to start with the easier one, option 2, that's the option you always have, also in normal times outside COVID-19. If your sum of wages to be paid out significantly is lower than expected before, you can file a request with your responsible AHV compensation fund in order to lower the contributions on accounts to be paid. Option 1 now is the new option, the special option for the COVID-19 times. You can also file with your responsible AHV compensation fund for a payment deferral for your social contribution payments, as covered are employers and also self-employed persons. In scope are AHV, IV, EO, ALV, but not the pension fund schemes based on BVG. Yeah, it sounds a little bit complicated, but you see it on the slide. Important to know there, these measures are, on the one side, these payment deferrals are interest-free for 6 months, but it's only temporary. And you have to be aware of that you must make plausible that you really have liquidity issues because of COVID-19. And on the other side, you have the obligation to make regular payments in account and to do an immediate first payment. So this was it for the second measure. I thank you for your attendance, and I now will give the word to my colleagues of PWC to cover some additional measures.
Hello, everybody. Good afternoon. My name is Ivana Vidakovic, and this is my colleague, Steven Aman. We are attorneys specializing in employment law, and together we lead the employment law department at PWC Legal in Zurich. Today, we would like to give you an overview on short-time work and the suspension of debt collection. As many other sectors, the crypto industry is also affected by the economic consequences of the pandemic crisis. One consequence is that employees can no longer be fully utilized. And for this reason, companies in the crypto sector are particularly dealing with one question: how can we keep our employees and at the same time lower salary costs despite reduced working hours? Well, our legal system provides us with a solution by means of short-time work compensation. For companies, it is important to know what short-time work actually is and how they can apply for compensation. Short-time work is defined as a temporary reduction of or complete suspension of work performance by the employees while maintaining the employment relationship. It is therefore intended to compensate for temporary reductions in employment and to preserve jobs. Under the short-time work compensation scheme, the public insurance pays 80% of the loss of earnings attributable to the reduction in working hours. The short-time work compensation is paid for a maximum of 12 months within 2 years. However, a monthly loss of working hours of more than 85% can only be credited for a maximum of 4 months. Furthermore, the compensation amount per employee is capped. As you can see, with the instrument of short-time work, the state covers a large part of salary costs for lost working hours in economically difficult times. And despite the fact that work is lost, redundancies can be avoided in this way. But what must a company do to receive short-time work compensation? Well, the employer must submit a request for short-time work compensation to the relevant cantonal authority, and it must meet the following criteria. The lack of work is likely to be temporary, and the governmental support can be expected to preserve jobs. The reduction of working hours corresponds to at least 10% of the total hours normally worked. That's the most important one. Other than that, there must be an adequate causal relationship between the reduction of the working hours and COVID-19. That means that a general reference to COVID-19 would not be sufficient to be entitled to get compensation. A company needs to demonstrate that the work performance of its employees is reduced or suspended due to measures ordered by the authorities or other circumstances beyond the control of the company. Furthermore, the company has to keep a time record showing the extent of the employee's absence from work. And last but not least, the employees have to consent to short-time work, meaning they must in particular accept a reduction in salary. Once the decision is approved, the company must submit necessary documents to the unemployment insurance fund every month, showing the work absences. The templates for the documents required by the cantonal authorities can be downloaded either from SECO's website or from the websites of the respective cantonal offices. The Unemployment Insurance Fund will verify the entitlement requirements, and if decision is positive, they will pay the short-time work compensation. So far, we have assisted a number of clients in applying for short-time work compensation, and companies with different businesses that are not equally affected by work absences must know whether they can apply for short-time work for the entire undertaking or for an individual business unit. And in principle, short-time work can be applied either for a business or for a business unit. A business unit within a company can apply for short-time work compensation if it forms an autonomous organizational unit which has a specifically allocated human and technical resources, and if it is subject to a separate internally independent service, or it provides services which can also be produced and offered on the market by independent companies. However, a business unit cannot independently apply for short-time work if only a small number of employees is affected, or if there's strong interconnection with other operating units, or if there's a lack of leadership function. In general, we can say that it always depends. If only a single business unit is affected by a shortage of work, then it maybe makes sense to apply just for that business unit. But if the whole company can reach a threshold of 10%, then we recommend to submit an application for the company as a whole. If you have any further questions to this, please send us a message. But which employees are entitled to short-time work compensation? In general, we can say the following. An employee who is liable to contribute to the unemployment insurance is entitled to short-time work compensation. In other words, employees over 18 years of age who have not yet reached the OASI retirement age, and therefore it is really important that there is an actual employment relationship, because in the crypto industry, we've seen a situation where workers are employed on a freelance basis, or as contractors, or in any different kind of relationship, a contractual relationship, and those employees would not be entitled to short-time work compensation. As a consequence, any employee in an ongoing employment relationship whose working hours are temporarily reduced or completely suspended is entitled to short-time work compensation. And last but not least, foreign employees are also entitled as long as they are affiliated to the Swiss social security system. That means that employees working from abroad would not be entitled to compensation. And with that, I hand over to Stephen.
Thank you very much, Ivana. Getting back to the subject of employees, in principle, only certain groups of employees are entitled for short-time work compensation. However, as a result of the current situation, further groups of employees have been granted the right to compensation for short-time work, which otherwise would not have been entitled to. So, namely, we are speaking of employees in an employment relationship for a certain duration, the so-called fixed-term employment. Then also, new under the COVID-19 circumstances, apprentices are entitled to short-time work compensation. Also, people employed by an organization for temporary work. And as a last group, employees who determine the decisions taken by the employer, or employees similar to employers, as well as their spouses. Just for an example, this would be a shareholder of a limited company who works as an employee in his own company for remuneration. For this whole group, a flat rate of 3,320 Swiss francs a month for a full-time position applies. Although the circle of entitled employees has been expanded by the Federal Council, still some employees are not eligible for short-time work compensation. So, employees under notice of termination are not entitled for short-time work compensation because this job will not be maintained after this period of short-time work. Then employees who did not agree to short-time work, employees whose absence from work cannot be determined because the working hours are very different through the months, as an example, the on-call employment relationship, and also the employees in the retirement age, because these employees don't pay any contribution anymore to the unemployment insurance fund. It should be noted that during this crisis, the state has made a few simplifications to the procedure of short-time work compensation in favor of the companies and also of the employees. So these procedural simplifications due to COVID-19 are that the registration waiting period has been, in the first step, reduced from 10 to 3 days and has now been completely abolished. In the application form of the cantonal authorities, it's just high-level answers that must be given to the questions asked. Then the public insurance can make upfront payments to the employer. Also, the payment waiting period has been reduced in a first step to 1 day and has now been completely abolished. This eliminates the employer's contribution to the loss of working hours. The employees no longer have to reduce their overtime first before they can benefit from short-time work compensation. Then the approval period for short-time work was extended from 3 to 6 months so that the number of applications can be reduced. And as I've mentioned before, additional categories of workforce are now also entitled to benefit from short-time work compensation during this crisis. So with these simplifications, the Federal Council is seeking to achieve the following two main goals. Firstly, the administrative burdens for the companies, but also for the cantonal authority, can be reduced. And secondly, as a consequence of this, the companies may be helped as easy and quickly as possible. We have already received various inquiries from companies in matters of short-time work compensation or short-time work. We can guide those companies through the whole procedure of short-time work, but we can also answer specific legal questions which arise, such as a company had in connection with the justification of the 10% limit for the lost working hours. So, to sum up, with short-time work, the government provides financial support to the companies affected and covers a large part of the salary costs that the company incurs despite of the loss of the work due to the coronavirus. But with another measure, the Federal Council is trying to relieve companies that have run into financial difficulties as a result of the coronavirus. This is the suspension of debt collection. On the 18th of March this year, the Federal Council decreed a so-called coronavirus-induced suspension of debt collection within the meaning of Article 62 of the Debt Enforcement and Bankruptcy Act. This Article 62 states that in the event of an epidemic, the Federal Council may decide that debt enforcement measures shall be suspended. So as a consequence, the creditors may not enforce debts relying on the statutory debt enforcement procedure. In particular, no debtors who can no longer pay their bills at the moment must fear of a debt enforcement. This suspension was ordered on the 19th of March and will last until the 4th of April 2020. In this connection, it has to be mentioned that immediately afterwards, from the 5th of April, the so-called debt collection holidays will start, and they will end on the 19th of April 2020. So with other words, there is a suspension of debt collection from the 19th of March until the 19th of April of the year 2020. To conclude our remarks, we would like to point out that you are welcome to get in contact with us, to ask us questions through the Q&As, or also get in contact with us with our email addresses or with the telephone numbers which we are seeing here on this slide. We thank you very much for your attention, and we hope that we gave a little bit an insight and useful information on the topics of short-time work compensation, and debt collection.
Thank you for your attendance today. We hope this event was helpful for you. Please stay healthy, stay safe, and keep tuned for future events.